This is Redwood Legal, this is the Court Wingman service, and we've been doing a lot of legal surgeries for clients over the past few months, and we find it actually really good type of service because, you know, you want to run your own claim, you want to save money, but you do need a little bit of legal input. So, today we're going to look at particulars of claim, and I'm going to refer to an extract from this book and use this video as a way of plugging the book as well. It is good, and I know it's expensive, but this is like 2 years of work. I really have tried to distill every essential, you know, up and down and tactical issues and drafting tips and samples of actual pleadings. You know, pretty much the kitchen sink has been thrown at this publication to help you, and it's been written in such a way that it's going to help you to run your own claim. I mean, that's the key here. Kind of the first thing to say about pleading, and obviously particulars of claim is a particularly important document, is that, you know, the first decision you actually have to make is whether your case is so complex that you're going to need a lawyer. And for example, in financial mis-selling, we often find ourselves saying to clients, oh my word, you brought this claim in the courts and now you've ended up with a court order, or worse, you've been met by a bank or a big corporation with an application to strike out your claim, and you've ended up on the wrong end of a £2,000 plus cost order, and the judge has told you to go away and properly particularise your claim. It seems a bit unfair to me that, you know, we should expect access to justice in this country, and yet where it's a complex claim, you need to find a large amount of money to pay a lawyer to do the drafting work. It's a fact of life. I'm sorry, civil litigation is, you know, it's not a fair and just world, and civil litigation is, you know, the leanest, the meanest, the fittest tend to win, the prepared tend to win. So that's just, I'm afraid, a fact of life. Another cases where we've had this happen is with a prosecution of the police. The client has simply had no idea how to bring a complaint against the police, even though there was proper merit in the claim itself. So that's the first question. Just eyeball your case, and if there is a complex head of claim involved, then I'm afraid you're going to need to turn to a lawyer for legal advice. Sounds like I'm plugging lawyers. I'm honestly telling you from the heart, because I've seen so many car crashes of clients who've come to us after the wheels have come off the train, the car has crashed, and you know, it's like, oh, you feel for a client, because you're then having to ask them for a whole load more money to actually apply to re-amend their claim, and you're already on the back foot tactically. So get it right first time, and make sure that it's you know, it's an animal, it's a claim that you can handle. Because if it's kind of low value, if it's very complex financial mis-selling issues, you'd really rather better just get on with your life and put it down to experience. Okay. Now, that being said, most claims are straightforward. Contract, negligence claims, basically all that's happening is, you know, in the case that I'm going to come on to, you have had a computer repair shop, you know, bugger up your computer, and actually done worse than that, deprived you of the opportunity of using that computer in your job. So, most claims are like that. Or your neighbour's driven his lawnmower into your greenhouse and destroyed your prized vegetables, and you know, and there's just quite a clear negligence claim. Yeah. So most claims are simple, and you can manage them yourself with the aid of a book. Haha. So before I come on to just drafting it itself, I will just also say one other thing, and that is be careful about whether it's a Part 7 or a Part 8 claim. Most claims, your claim is probably Part 7. It's a standard claim for money. Part 8 claims are kind of complex, esoteric claims, issue of law, certain specialist types of heads of claim, an Inheritance Act claim, contesting a will. There's a list of those types of claims that have to go the Part 8 route. That's not the topic of the day, but just make sure that you're using the right runway to get lift off. Now, let's just talk about a really important topic before we come on to the particulars themselves. Issues. What is an issue and why is it so important to get your head around it before you start drafting? The problem is litigants in person tend to just use a scattergun, kitchen sink approach and throw everything into their particulars of claim, including evidence, which you should never include in the particulars of claim. That's for a later witness statement later on in the proceedings. So, and it's kind of, they're just afraid. They just want to throw everything in so at least something sticks. Well, maybe something will stick, but maybe more significantly, the judge will overlook the key issue that you really want resolved by him. So issues in civil proceedings, civil litigation, are framed as the question that you want the court to answer, to resolve. That's what an issue is. So just to give you an example, if you are, you've got a neighbour who's driven their lawnmower into your greenhouse, the issue might be he wasn't looking where he was going. You might want the court to decide on the issue of whether or not he wasn't wearing his glasses. Yeah. You might want the court to decide on the issue of whether or not there'd been regular maintenance done on that lawnmower, which let's say was an industrial ride-on lawnmower, because you allege that he put it into the wrong gear, or that the gears were faulty and therefore it accidentally reversed into the greenhouse. Then that's another issue, independent of the eyesight issue. You might have more than one issue in your case. But you need, and I see this in court orders, where the judge just sends a court order saying, go away, litigant in person, properly particularise your claim by identifying the issues that you want me, the judge, to decide upon. Okay. In the case of the contract claim that we're looking at here, the issue is, has the computer repair shop, has the staff in it been careless? So, make sure you've understood the issues. It's a big topic in a way. I go into it in the book, really. You can also buy single copy versions of this. We've got 7 parts that you can buy on Amazon in single versions if you just want to target a particular area of the litigation process and not spend all your money on the one big guide. So that's the issues. So now let's go on to look at how you draft a particulars of claim. Notice how it's kind of quite simple, really. You're just telling the story in a chronological fashion. Yeah, on the 5th of February, da-di-da-di-da, Jack Spratt was mowing his garden, da-da-da-da. Number 2, each event has a separate little paragraph and you number them. You then, having told that story in the events that basically comprise the substance of your claim, and you be concise. The civil procedure rules themselves tell you that you must be concise when drafting your particulars of claim. You then come on to particularise the breach. Okay, so if it's a contract claim, you're always claiming in a contract claim for breach of contract, but the breach of the contract here is a breach of an implied term that the work will be carried out with reasonable care and skill. Then you don't do just that, you particularise the way in which they've been careless. And notice we've teased out the ways in which we allege the repair shop has been careless. So you try and focus and target. That the power of this is, if you send this particulars of claim to your defendant, and you could send it in draft form to them before you issue, threaten them, they're going to go, oh, hang on, so yeah, we did have that person and they actually were a trainee and we didn't really think their work was much up to scratch, but we told this chap that we deny carelessness. It might get them thinking about what really went on, and they might think, oh, okay, fess up, we'll make him an offer. So particulars of claim, can actually help sort of put a laser focus on their weak spots. And litigation is a samurai warrior fight, my friend. It's not friendly and fluffy, unlike criminal law, which I did back in the day. It's where money is concerned, people are ruthless and people will try and wriggle out of anything. So then you finally go on to what's a really important sector that so many people overlook, and that is particularising your losses. That's what you're here for. You're probably not going to have a bun fight about the fact he was on his lawnmower and wasn't wearing his glasses, or the lawnmower was broken, hadn't got a maintenance record, a repair history. So you probably, he might concede that, probably will, but he's not going to pay you 10,000 because you've pleaded for, you know, expensive glass and a prize marrow, £5,000 or whatever it might be. That's where the battleground is so often. That's where the battle so often takes place in civil litigation, is the losses. How do you make sure to win that losses battle? Particularise them. And in this case, notice how we've particularised the fact. Not just that he had to buy another computer, not just that it was a bespoke computer, not just that, you know, he had to spend a day building the computer, but that he had other losses. Losses because he couldn't do his normal work for his clients, being self-employed. Losses, sort of a kind of like a fair and reasonable general figure of £500 for losing all the contacts on his phone. Notice how when you go and really do the exercise and break down the losses, you can come up with quite a sizable figure. We find we can often add real value to people's claims, particularly in this area. For example, where you've got, say, a building dispute and it's a professional landlord who needs a property renovated by a certain date because you know, they're a business and they want to rent it out, and that's been agreed. You know, particularising the loss of rents and evidencing that, not during the statements of the case phase, but later on, by, you know, estate agents' letters saying what the value of that property, the rental yield on that property is. So you might have had building works and had to stay in a hotel because you went over time. That could be quite expensive, or travel costs, or having to, you know, go further to take the children to school, and it costs you more money in petrol. So just do the exercise of breaking down, particularising your losses, not just focusing on the fault side of the case. Finally, you've got a catch-all in this, which is pre-action conduct. If they've been particularly poor, the proposed defendant, in terms of replying to your letter of claim, which obviously you should have sent before you draft your particulars and issue the claim, then you might want to make a point of that and emphasise that. You know, again, target the weak spots, and you want the judge to see that they haven't engaged with in a proper way with the pre-action phase of litigation, haven't tried to avoid the need for going to court, which will make judges angry. So there it is. I will just finally reiterate that be concise, don't put in evidence, don't say, and the estate agent says that by letter received on such and such a date that the value of the rental yield of the property is £5,000. Just say the rental yield is £5,000. The fact that the estate agents later on provided you with a letter and give you evidence of that is not to be supplied with the particulars of claim. It goes in your witness statement at a later point. Okay, I hope that all makes sense. If you need any help and advice, courtwingman.com or email us. I mean, I think this is a really good development here. We're now doing quite a lot of work in trying to add value, because I often think that people think there's either a choice of use a lawyer or do it yourself, and one seems expensive, the other seems time consuming and risky. So we try to offer a middle way where we are your wingman, obviously, in helping you fly the plane yourself and to win the litigation battle with our assistance. That's all for now. Thank you for tuning in.